Imagine if the most popular rifle in America, the AR-15, and magazines were declared outside the protection of the Second Amendment. That's not a hypothetical. That is currently up for consideration in the Supreme Court. And the question before this court is a very simple question. Does the Second Amendment guarantee the right to possess AR-15s and magazines? And now the court will consider those questions today. So let's break down what is happening in this critical case. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also double check to make sure YouTube is not unsubscribed you. I also want to thank the sponsor of this video, which is Patriot Gold Group. With the Fed currently pivoting to cut rates, that means just one thing, that there is going to be more money printing. We see that the job market is also cracking, and there's a lot of concerns also about mortgage rates and also mortgage distress, and the searches are all the way back up to 2008 levels. There are major voices in the finance industry that are also warning of, that 2026 could be more explosive than we've ever seen before. And all of this is happening while our national debt skyrockets and passes $38 trillion. Now, on the flip side, there have been a lot of positive movements when it comes to gold, and major banks are also saying that gold could reach potentially $5,000 or even more an ounce. And look, I know if you're a gun owner, you already understand that hedging against uncertainty really means a lot to you. And when the system kind of gets shaky, you want to protect yourself and protect what matters. And your finances should also not be any different. You should also protect that as well. Patriot Gold Group helps Americans secure their retirement with physical gold and silver delivered to your doorstep or stored in a no-fee for life IRA. They specialize in helping you roll over your IRA or your 401k into real, tangible, precious metals like gold and silver, and that is something that you actually own. So if you're interested, call the proud Americans over at the Patriot Gold Group today before it's too late, and mention Armed Scholar to get the best in class service from patriots who are focused on protecting other patriots. You can also call 888-581-3830 for your free investor guide to learn more about protecting your money with Patriot Gold Group. Now, as I mentioned in the intro, in this video, we're going to be discussing a critical rifle and magazine ban challenge that went in front of the Supreme Court and went to conference today. The primary case that I want to talk about is called Viramontes versus Cook County. And in that case, the petitioners are individual citizens along with organizations like the Second Amendment Foundation. They're challenging Cook County's ordinance, which makes it a crime to sell, transfer, or even possess so-called assault weapons. And that term in the ordinance covers about 100 rifles by name. And then also it has a firearms, characteristic ban where it bans certain firearms with features like pistol grips, folding stocks, muzzle brakes, and other characteristics. The plaintiffs in this case argue that this ban does not just regulate firearms, it outlaws some of the most common and popular rifles in America, which are protected under the Second Amendment. This case tries to leverage the recent statements made by Justice Kavanaugh after the Snow denial of the rifle ban case, which happened last term. And in that denial, Justice Kavanaugh stated that the time will come very soon that they will need to take up a rifle ban case and they will need to address that issue. So he indicated that they would do that in a term or two. And the plaintiffs are pushing this Viramontes case, as that vehicle for them to finally address that issue. And also, right now at conference today, there was another case that was up for consideration, which deals with magazine bans, and that is the California Duncan case, which was prior granted, vacated, and remanded by the Supreme Court. And they're also pushing that Duncan case, the magazine ban case, for review. They want it to be granted by the Supreme Court to also strike down state rifle bans. Now, here's how the rifle ban case currently got in front of the Supreme Court. Essentially, back in 2021, the rifle ban lawsuit was filed in a federal district court in Chicago, and the petitioners in this case challenged the county's ban under the Second Amendment. So in 2024, while the case was pending, Illinois then passed a statewide assault weapon ban, which overlapped with Cook County's restrictions. And that new state law was the Protection of Illinois Communities Act, which is called PICA, and we've talked about that law in the past. Now, around that same time, the Seventh Circuit decided a case called Bevis versus Naperville, upholding Illinois' law and claiming that AR-15s were too militaristic to be protected arms. They ruled that firearms which are useful in military service could be outright banned, and the district court, bound by the Seventh Circuit's ruling in the Bevis case, then ruled and upheld this decision here, upheld this Cook County ordinance and restriction on rifles of these characteristics. They said that they're assault weapons and they could be banned because they are militaristic in nature. The district court issued a summary judgment in favor of Cook County, and in 2025, right after the Snow petition was denied by the Supreme Court, the 7th Circuit then reviewed this Cook County case and affirmed what the lower court said. The 7th Circuit leaned heavily on the Bevis ruling, treating AR-15s as essentially civilian versions of M16s and therefore outside of the Second Amendment's protections. Now the petitioners are asking for the United States Supreme Court to step in and resolve this conflict. They ask for the Supreme Court to declare once and for all whether Americans have the constitutional right to own AR-15s and similar semi-automatic rifles that states are now outright banning. The petition argues that circuit courts are split and deeply confused on how to actually apply Heller and Bruen and Supreme Court precedent. Some courts say that AR-15s are arms but can be banned anyways. Others claim that they're not arms at all and therefore they're not afforded two-way protections. Petitioners say that the Supreme Court needs to clarify that all firearms, including semi-automatic rifles, are arms under the Constitution. And in the Supreme Court petition, they introduced surveys, production numbers, and sales data to show that tens of millions of AR-15s are in circulation. They point out that they are used in home defense, target shooting, hunting, and other lawful purposes, and they argue that if the Second Amendment does not protect these most widely owned rifles in the nation, then according to that type of rationale and that logic, then no type of firearm is actually protected. Cook County has also filed their response to this case, and that's also going to be considered by the Supreme Court at conference, and they argue that this case does not warrant the Supreme Court's attention for multiple reasons. First, they say that there's no circuit split in the lower courts. Therefore, since there's no circuit split or no conflict on this issue, the Supreme Court does not need to address this case. They argue there is a consensus of the lower courts of circuit courts like the 9th Circuit, 1st Circuit, 2nd Circuit, 4th, even the 7th Circuit. And since there's no conflict, they need to simply punt this case. Second, they claim that this case is a poor vehicle since they argue the plaintiffs failed to follow some basic court procedures. And here, the Cook County argues that the petitioners here, the plaintiffs here, were in such a rush to get to the Supreme Court that they did not follow all of the rules. Finally, Cook County contends that the lower courts were right on the merits, and they were right even if you ignore all the other issues. They say that they were right on the merits, that these AR-15s are dangerous and unusual weapons that are closely related to M16s, and therefore they do not have two-way protections. So in short, they say that this case is procedurally defective, legally settled already in the lower courts, and not the right vehicle for the court to revisit these types of assault weapon bans. So at its core, this case asks for the Supreme Court to finally do what we have been asking for them to do for years, which is take up a state rifle ban and hopefully strike it down. This case went to conference today, so December 5th. It went to Supreme Court for consideration, and it went with a bunch of other two-way cases like the California Duncan versus Bonta case, which deals with California's ban on magazines that hold more than 10 rounds. Duncan is a case that was already granted, vacated, and remanded by the Supreme Court, a few years back after Bruen. But like other two-way cases, it is now suddenly back in front of the Supreme Court after all of these years because lower courts continue to refuse to apply the proper two-way analysis. They're in some ways also outright defying what the Supreme Court said in Bruen. They're not doing two-way analysis, and that has led a slew of cases to make their way back to the Supreme Court. They all went to conference today, and now we're going to wait to see how the Supreme Court deals with these issues. To this point, the Supreme Court has avoided rifle and magazine ban cases like the plague. However, we will know really soon whether Kavanaugh's promise that they will take up this issue in a term or two was actually true or just another empty promise of the Supreme Court. And so we're going to find out really soon if they will continue to avoid these issues and allow the lower courts to continue to run amok when it comes to state rifle bans and state magazine bans. We will now keep our eyes on the next Supreme Court order list to see what the Supreme Court decides to do. On the order list, we would see something like a denial, a grant, or we would see nothing. And then what we would see is potentially a relist of these cases for the next conference. And so that would indicate that they're pushing this out or they're going to, reconsider it at a new conference. So that's what we're going to be keeping our eyes on during these following weeks. And as we get more information, as it develops more, I will let you guys know. So if you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All those things help to fuel the algorithm. But as always, thank you all for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.